Right, Steph, many thanks for that introduction. And I think Steph has characteristically hit the nail on the head by appreciating the concern about sleepwalking into some pretty drastic changes as a result of what were meant to be temporary changes. I'm going to start by going back further than March 2020 and those apparently initial changes, though. I'm going to start by talking about what the civil justice landscape looked like pre-COVID. I appreciate that many of you who are listening to this talk will have been working in the civil justice landscape long before LASPO came along. But it's worth recognising in any discussion about the impact of changes on the civil justice system what a radical effect LASPO has had. We all know that it came into effect in April 2013, slashing many areas of civil legal aid. I've mentioned some, but not all of the areas that were taken out of scope for legal aid on this slide. And we can see how diverse and wide-ranging they were. I've also noted that, of course, the financial eligibility criteria were tightened as a result of LASPO. And the effect of that was a huge drop in the number of civil claims being brought on legal aid. The statistic that you've got in front of you on that slide comes from the MOJ itself, noting that there was a 74% drop in civil claims funded by legal aid between 2012 to 13 and 2016 17, which was even greater than what the government's own estimates at the time of LASPO thought there might be. And that precursor to COVID already amounted to a significant barrier to access to the courts and vindication of the rule of law for many people. There were also, of course, significant effects to court funding, including in the civil courts, and as I'm sure Joe will mention in the criminal context too. We've all seen in our day-to-day practice the crumbling court estate, but relevantly, the fact that Chris Grayling, when he was Lord Chancellor, was willing to lean in so hard for cuts to the Justice Department meant that court modernisation couldn't properly happen. We couldn't make sure that we had the kind of civil court system, especially for day-to-day legal aid cases where significant issues are at stake, that would allow for effective remote participation. So now I'm going to come forward in time and I'm going to ask what happens when austerity meets a pandemic. And my notes for this slide just say chaos. I'm sure we all saw that in our own practice. I think my reference here to widespread adjournments and delays is perhaps something of a euphemism. Huge numbers of cases, including cases raising urgent issues, were simply postponed. And whilst judges in most cases attempted to be pragmatic, and whilst the Courts and Tribunal Service were keen to facilitate protecting people, the immediate impact of COVID was that many people were unable to have their case heard in a timely way. And I'm here going to be an absolute cliche and roll out, of course, the famous idiom that justice delayed is justice denied. And for many of our clients, that's what COVID meant. However, I'm speaking here as a legal aid practitioner. And what the Civil Justice Council's rapid review in May 2020 found was that there was a divide in practice between certain courts, I'm thinking here particularly the higher courts and the commercial court, that are very well funded, that had live streaming, that had remote hearings, that had proper technology in place, and who were able to transition fairly swiftly and fairly effectively. And the lower courts, the Immigration Tribunal, SEN tribunals, we're thinking about MAGS courts, county courts. All of these courts had suffered from years and years of cuts, and it meant that they simply weren't ready to transition to a mostly online way of working. There are two significant rule of law issues that arise that I'm going to focus on in my limited time. Firstly, there's the question of how open justice is affected during this time. I've referred here to the coronavirus practice direction that came in, and that attempted to be a pragmatic way of encouraging courts to broadcast hearings where they could, to involve the media where they could, but also to sit in private when that wasn't reasonably feasible. However, the focus of this practice direction, the focus of many courts, has been to facilitate open justice by allowing the media to participate. And as I've noted here, access to the courts for the media is not open justice. And what the CJC and other bodies have found is that there have been significant problems for members of the public who've wanted to participate in hearings about learning when they're going to be taking place and then attending them remotely. So that presents a significant rule of law problem. I also am going to suggest it presents a significant rule of law opportunity. Open justice could be meaningfully facilitated widespread use of remote hearings that were properly available online, where people could learn about them in advance and attend them with ease. If that were the case, it would actually mean a greater system of open justice than before. The second issue for the rule of law principally is access to legal advice and representation. I've quoted here from a Law Society report that noted that not only were many people literally shut out of court, particularly some of the most vulnerable and institutionalised people in our society were unable to access representation or to participate meaningfully in hearings as a result of the move to online only. The Law Society focuses on people in care, in prisons, in immigration detention, in mental health settings. And often these people do not have adequate technology, nor has the Ministry of Justice provided them with adequate technology to engage meaningfully in hearings or even to seek the advice that would get them to that stage. And as is noted here, this is an essential element of scrutiny. And going back to Sonali's talk and Kate's talk, they were, of course, emphasising that many of these people have been additionally vulnerable during this time. Finally, before I run out of time, I'm going to talk about what happens next. The House of Commons Justice Select Committee's report on the impact of COVID on courts concludes that COVID shouldn't be used as an excuse for bringing in permanent changes without prior consultation and suitable evaluation of their effects. That has to be our guiding principle going forward. And we as lawyers, and I'm speaking for myself here as well as everyone else, mustn't allow convenience and the ease of remote hearings to mean that we fail to suitably identify the shortcomings, particularly for the kind of people that we often represent. I've referred here, for instance, to the radical changes that took place in the upper tribunal, the move to decisions being presumptively made on the papers, which has, I understand the judicial review challenge to that has finished today in the High Court. That's one of many examples of a radical shift that may well stay in place after coronavirus is merely a memory. And we need to keep identifying these problems, identifying where there are opportunities, and identifying where something is no longer strictly necessary as a result of coronavirus, and pushing for it to be repealed. Thank you very much. I think that's my time. I'll hand over to Jo now.
Thanks, Miranda. I'm just going to share my screen, hopefully, she says. Perfect. So I'm here to discuss today the impact of COVID on the criminal justice system, and many of the themes that Miranda and others have already touched upon really flow through the impact within the criminal justice system as well as the civil justice system, and you'll see that there are concerns that effectively mirror each other, which is perhaps unsurprising. The first aspect I want to touch upon is just the pre-COVID criminal justice landscape. A little bit like civil, a system that can only be described as being in crisis, a decaying court estate, a sell-off of courts across the country, cuts upon cuts upon cuts, both in terms of the legal aid provision, but also just in terms of the actual resourcing of by a HMCTS of the system. Huge fragility in the provider market, and I'm sure you don't need me to tell you about the ageing population, for example, of criminal defence solicitors, or the legal aid deserts that exist in crime and are increasing on a daily basis. And perhaps importantly, for the purpose of what I'm going to talk about primarily today, which is the government's response in relation to trials and the lack thereof of trials, significant delays within the criminal justice system. And so delay was something that was effectively routine within the criminal justice system prior to COVID. Of course, then what happened was COVID hit. And I've just headlined out a couple of issues here. Prisons, as has already been touched upon by Kate, conditions of detention, access to family, prisons obviously being significantly under-resourced, access to clients in custody. Those issues continue to, unfortunately, provide significant barriers to us all. Certainly you'll have seen some appointments aren't until December of this year, and so on and so forth. How you're supposed to prepare for a trial or get things progressing in that sense is beyond me. Significant issues in relation to the technology that was being deployed, all sorts of different technological platforms. What was notable, however, was the commercial and corporate courts could get up and running in the chancery divisions, but criminal courts were just left floundering. Remote hearings. We've already heard a little bit about the issues regarding access to justice, effective participation, and of course, open justice. But for the criminal justice system, one of the biggest challenges has been in the Crown Courts and in trials, jury trials, for relatively obvious reasons, owing to the number of participants that you have to have in a courtroom at any one time to conduct a jury trial. It's fair to say that despite every effort by the profession, and I say professions, I should say, very limited resources were then put into the criminal justice system. Instead, effectively patch solutions were sought to be found. So remote participation, we've had a trial whereby if defendants have beamed in from the prison, we've had a couple of trials whereby 2 courts are being utilised. We're finally getting some perspecs, which as a colleague of mine remarked, Primark had them from the outset. I think practically every coffee shop I've walked into has had them from more or less the outset, but for whatever reason, we couldn't manage that. We also couldn't manage basic facilities. We were asking for hand sanitizer. We were told, well, you've got washing facilities at court, and it had to be pointed out that actually we don't have hot water. We often don't even have cold running water. And have you seen the states of our current courts in the criminal system? Then we moved obviously back to HMCTS's PET pilot project, which pops its head up every so often. Now called extended operating hours, previously flexible operating hours, more or less the same thing. We've had pilot after pilot in this regard, and yet once again that seems to be the HMCTS's answer to the problem, not to resource courts properly, but let's just try and extend the working day and have a few evening courtrooms. Nightingale courts. Well, we saw the fairly impressive response in relation to Nightingale hospitals. Courts somewhat lacking, some might say. So we now have effectively 8 courtrooms up and running, the majority of which cannot hear trials with defendants in custody. That, unfortunately, is the biggest challenge for us in the criminal justice sphere right now. And so we come on then to the government's next response. First of all, we heard about judge-only trials. Then we heard about judges sitting with 2 magistrates. And all of these really were the forerunners to what then came into force, which is the extension to custody time limits. So custody time limits, I'm not going to go through that in any great detail, only because of the length of time that we've got, but essentially they limit the length of pre-trial detention. Its purpose is to protect the liberty of the citizen, assumed obviously, one might say, to be not guilty at that precise moment in time. And I've set out where the relevant provisions can be found. Importantly, the actual limits themselves are set down within the regulations and are designated by the statutory instrument, and that has an important impact when it comes to looking at what's happening at the moment, and of course the broader landscape of how the government are responding to the COVID crisis, which generally means the laying, as we all know, of statutory instruments absent any real parliamentary oversight. And so just to give a bit of background, previously, and I'm going to concentrate on the Crown Court, we were looking at 6 months as a custody time limit, after which, upon application, it could be extended. The relevant test, and this is relevant for our discussion today, was firstly that there was another good and sufficient cause for extension, and that secondly, the prosecution had acted with all due diligence and expedition. And it's really the first of those that engages the COVID issues that we're all seeing. And what has always been relevant to that assessment is the availability of a courtroom, and certainly in relation to courts, were a court not available at a court centre, then we had to look at other court centres around the country. So jury trials were suspended. This is really going to be a complete whistle-stop tour. Applications were made to extend CTLs. They were initially granted. There was a protocol that was brought into force said not to have an impact on individuals' decision making, but ultimately was very much, well, this is a just and sufficient cause, COVID in itself, the pandemic. And of course, one can understand that when it was introduced, which was back in April, effectively the beginning of it. That was withdrawn at the beginning of September, and then followed by the laying of the statutory instrument. It only applies to cases from the 28th of September, but it extends that period of time now to 8 months. Effectively justified on the basis of COVID. I'm not going to go through it in detail, but you'll all be well aware that actually the delays that we are experiencing were pre-COVID. And COVID, frankly, is being used as a smokescreen as a result instead of sitting days. And frankly, it's the very definition of irrational to import more delay into a scheme that is said to be trying to limit delay. So then what we had was increasing concerns because judges began to refuse those applications to extend. There was a relatively explosive ruling down in Woolwich Crown Court, which alleged not only that there was improper pressure being applied by the senior judiciary, but also alleged irregular listing practices for CTLs. Ultimately, it all came down to a failure by the government to resource trials properly. So was there any impact assessment conducted in relation to the CTLs? Short answer is no, and I've set out the explanatory note there. There was also the failure to consult the Children's Commissioner. Now, why is that important in the context of CTLs? Because, of course, there is an impact, and the impact is fairly acute. So first of all, you have the impact upon the innocent, with over 3,000 people being acquitted, and now obviously potentially spending significantly longer times in remand if those proportions follow through as they generally do. Children, some 45% of children were on remand compared to 37% of adults. So we see already a disproportionate impact upon children. And as we can see, almost half of those, even when they were convicted, did not receive that immediate sentence of imprisonment. And we then have the impact upon those who self-harm and vulnerable categories and mental health. And moreover, what we also very starkly see are the implications in relation to BAME and BAME communities. And so effectively, and I'm going to scoop through these aspects at the moment because you'll all have the handout in due course. You may have seen a potential legal challenge that I'm involved in along with others from Doughty Street, and that involves the Howard League, Liberty and Just for Kids, who wrote to the various ministers setting out their concerns. Not a pre-action letter, this was setting out the concerns and asking about impact assessments and seeking disclosure. In short, after some to and froing, the equality statement has now been published, and somewhat unsurprisingly, it accepts that there's indirect discrimination, that BAME in children are disproportionately impacted, and of course, one then has to look at the impact on BAME children. And instead, what they say is that they state that it's justified because of the exceptional circumstances of the pandemic. And so it's a fairly bold assertion that we have a statutory instrument that on its face the government simply imports yet another aspect of discrimination into our criminal justice system with already all of the challenges it's facing, and certainly somewhat disappointing in light of the Black Lives Matter movement. So I hope that's been a bit of a whistle-stop tour. There's a couple of slides then on extended operating hours, as I've said, aka FOH. We've been here before, we're going round in circles. But that concludes ultimately my talk. As you can imagine, all of us can probably talk for hours on all of the problems that we're facing, but also all of the potential challenges. And there are many, and again, not seeking to be an activist lawyer, but really we do have to challenge some of these things. Thank you very much.
So that's our final contribution.